fabricated or made up. So generally, if the defendant does not testify, his prior statements, if offered by him, are generally excluded in evidence. And that's the case I just cited, the Boyer case I cited, which also cites to a case called State versus Ryan, no relation, 157 New Jersey Super 112. At pages 126 and 127, that's in a television case from 1978. The doctrine of completeness is really not applicable here. We're talking about the doctrine of completeness. For instance, the state highlights a particular statement made by a defendant. Let's say the state was trying to use something at the hospital, at a motor vehicle stop, with a body worn camera. The defendant then states that in order for that statement to be considered by the jury in its full context, the statements preceding it or following it need to be admitted. Here we're talking about apparently a couple hours worth of the defendant's encounter with Alcoa police. None of them were here to testify. Obviously, it's difficult to subpoena a witness from out of state, but either side could have done that. The officers make a variety of disparaging remarks about New Jersey. They obviously have little information about what's going on or what they can do. Not even clear that there was an alert for the car based upon what they've said. Well, obviously, they stopped the car for a reason. The officer attributes the car being stopped to speeding in a construction zone, 8 miles an hour over. But then there's some discussion about a murder suspect. On balance, if this statement was offered by the state, if this video was offered by the state, assuming it was authenticated by the Alcoa officer, I'd be hard-pressed to allow it because it's full of prejudicial things to the defendant. He's already got an attorney. He's been driving straight through for 20 hours, leaving. May want to go as far as California. Thinks he might have been in Texas. Has been arrested before, although arrests aren't even relevant. Even a conviction wouldn't necessarily come into evidence, at least not at this point in the case. So there's way too much hearsay by the officers. There's conversations about other types of matters. And then we get to, I'm going to use the page numbers in the exhibit, pages 31 and 32. The Tennessee officer is talking about New Jersey maybe coming to get the vehicle, but it's going to take a long time. It's Easter. He talks about putting an evidence tag on the vehicle. Then we can get you underway. At line 1287, defendant asks, are they not responding? Is that why? The officer answers, we're having a hard time. New Jersey sucks, all right? And then there's some further discussion. A lot of it's unintelligible. You know, no one's asked for what's known as a driver hearing, but it's hard to understand a lot of what is said in this video. The officer then says, we've already talked about this. I don't want you to be here all day. The defendant says, I understand. The defendant then says, the situation currently, I understand and I have no problem with that to have a tech process the vehicle. That's completely fine with me. He also then talks about waiting a long time, maybe their jurisdiction, presumably referring to New Jersey, put the defendant in a hotel room. The defendant asks how long it would take for the vehicle to be processed. The officer is talking about, depends how long it takes someone to get here. The officer then says, we'll dump the phones, which is typically how they do it. Then asks, what do you mean dump the phones? The officer asks, so they, every time they process a vehicle for evidence, they take your cell phone, and they dump it. And says, I don't know what that means. Then asks, they get the data from it essentially. The officer's responses are unintelligible. There's some woman speaking in the background. He says, okay, yeah, I have no problem with that. And I'm able to, reach out to my family at some point and just let them know what's going on. terms of the defendant turning around and coming back from Arkansas into Tennessee, defense has other admissible means of being able to produce that in front of the jury. First, defendant's father's already testified to that. Secondly, Detective Coles may have been asked about it. If not, he can be called by Mr. Gallucci. At a 104 hearing, he presented to the court a PowerPoint which included a map with 60,000 data points which showed a U-turn essentially in Arkansas. Coles testified it was southwest Arkansas and the defendant was coming back through Tennessee, and geographically that seems correct. In terms about the point of dumping the phones, whether that's consent, and it's hard to even see about is the defendant consenting to all this. So this thing about the tag or a tech putting a tag on there, it's unclear to me that that even needs a full search. The officer from Tennessee is saying, at line 1271, so I can get an evidence tag, process the evidence, and make sure there's nothing there. Then you can go on your way. The defendant, I have no problem at line 1303. I have no problem with that to have a tech process the vehicle. I'm not sure they're talking about the same thing. But regardless, I tried to, I guess I imagined this was simpler or clearer than it seemed, and that it would briefly show the defendant being pulled over and being cooperative. So while I've endeavored to allow it to be admissible in some fashion, because any evidence which could potentially be consistent with innocence, such as returning back, could be admissible, it still has to somehow satisfy our rules of evidence. Monumental amount of inadmissible prejudicial evidence, all hearsay, with perhaps some evidence that the defendant turned around and came back, which is otherwise presentable to the jury based upon Sergeant Cole's defendant's father, who's already testified, and perhaps any other legitimate way Mr. Gallucci can get it into evidence. But at this point, I have to be a gatekeeper for admissible evidence in front of the jury. I'm not even sure the jury can understand most of what's said. In the beginning, I thought the initial inception of the stop, not the initial, but the inception of the stop would be something that could be presented. If anyone reviews this record, the video shows the officer walking up to the car. The body cam we're looking at, body cam of an officer behind him. You can't even see the defendant. You just see the police officer there with his hand on his gun, looking into the vehicle, which is not particularly positive for the defendant either, making comments about the defendant reaching around, some comment that the defendant's reaching to the side of the door for his wallet, but the officer's telling him his wallet's in his lap already. So that's certainly not helpful to the defendant. It looks like he's making furtive gestures or something like that. So my initial thinking that there could be some neutral presentation of just the defendant being cooperative and not being difficult with the officers or not attempting to flee or resist further is not something that comes out from the video. If there's further witnesses or further testimony that changes that, that's fine, but I can't have it played under these circumstances. But I think, as I indicated, that it's already been established that the defendant rented a car and came back. The defendant's father established he wasn't arrested in Tennessee. He wasn't even charged until July with the endangering. The state didn't challenge that, doesn't dispute that. Didn't cross-examine the father on that issue, about the accuracy of that issue. So, I think the jury's going to obviously know he came back. Mr. Gregor came back from Tennessee on or about 5th or 6th of April. So, under those circumstances, we've watched a substantial portion of this, but for those reasons, it can't be admitted to evidence, at least not under the current proposal without witnesses here. Mr. Galucci, anything else you want to address today?
No, Your Honor.
All right. So we're gonna report at 9 tomorrow. We'll have the jury come in at 10, and hopefully you'll have some witnesses.
I'll be here at 8:30. I think that Mr. already said that a lot of the witnesses will be here at 8:30, so this way I have an opportunity to speak to them. I'm also going to request now, if Detective Sergeant Coles is available, I'll get Ms. Ferrante tomorrow. So this way I can get all of my police witnesses, talk to them all in the morning, and then put on who I believe will be helpful.
All right. And the state has no problem with Mr. Galucci trying to speak to the officers in advance of the testimony?
Judge, without an investigator, that's not something that would be a normal practice. I mean, I guess it's really up to the officer themselves if they want to testify. I'm sorry, if they want to speak to him or not, but, I mean,
Judge, I'm not
we plan on coming over in the morning as well, too.
I mean, whether they answer questions